Good morning, everyone. Thank you for coming. I have the great pleasure of chairing the first panel. I also wanted to emphasize that I really appreciate the fact that the organizers have put the comparative law aspects in the first panel, because it's very helpful for all of us to see what other jurisdictions are doing. So what we want to do today is basically give you a lay of the land of how different jurisdictions from Australia to Canada to the United States, the UK, and the EU are dealing with fiduciary duties and climate change issues. So I just want to briefly introduce the speakers. We will not go in alphabetical orders, if only because we have too many people with W and therefore in their last name. But no, I think we wanted to have it more like topic-wise. So we will be going like a tour of the globe. We will do Australia, Canada, the US, UK, and Europe this way. So I'm going to first introduce Sarah Barker, who is the Managing Director at Transnational Law and leads the Climate and Sustainability Risk Governance team there. She was previously a partner at the Asia Pacific's largest commercial law firm, Minter Ellison. She's the co-chair of the World Economic Forum's Global Future Council on Climate and Nature Governance, and immediate past co-chair of the forum's climate governance community of experts, starting from March 2025. Our next speaker will be Cynthia Williams, who joined the Murrow School of Law as a visiting professor in August 22 and is now a full-time faculty member there since 23. She's been at Usgood Hall Law School before and Osler Chair in Business Law from 2013 to 2022. Before coming to our school, she was a member of the faculty of the University of Illinois College of Law, and prior to that, she practiced law at Cravath. She's an expert in corporate law, corporate governance, and deeply knowledgeable in the area of climate and corporate law as well. On my far left is Andy Winden, who is an assistant professor at Oregon University School of Law. Prior to the study prior to this, he was at the University of Florida, and previously he was a fellow at Stanford's Rock Center for Corporate Governance, a partner at Morrison & Foerster, an associate at Sullivan Cromwell, and an honors attorney at the Treasury Department. He teaches business law and has scholarship in corporate governance, securities regulation, and sustainability. And then last but not least, who's going to be like the double whammy of doing both UK and the EU, which of course is no longer the same and would always be, of course, multi-layer as we are in Europe. Tom Wetzer is an associate professor of law and finance at the University of Oxford and the founding director of Oxford's Sustainable Law Program. His research explores how to align private initiatives and the public good. He studies how legal and financial mechanisms address or fail to address governance challenges generated by the presence of externalities, with a particular emphasis on climate change and financial stability. So I've asked each speaker to spend about 10 minutes to explain the particular approaches that his or her jurisdiction is taking on these issues, or the jurisdictions they are familiar with, I should say. We'll just go around, then I will ask them to talk to one another. I might prepare some questions as they speak to make sure that we have a coherent discussion, or maybe also sort of draw out some differences. We had a very interesting prep discussion this past Monday, and so I think we can really go into some of the details as well after we just get a broader overview. So without further ado, I'm just going to turn over to Sarah Barker, and then we'll continue in the order that I suggested, and I'll just take a seat over there and come back for the discussion.
Morning, everyone. Now, excuse me if I fall asleep halfway through the day because I arrived from Australia yesterday. Okay, I'm pretty loud. So I've come from 35 degrees Celsius to less than 35 degrees Fahrenheit, and I'm really not coping very well. So my remarks this morning, I'm going to do three things. First of all, I'm going to give you some context around how Australia and the rest of the world, particularly in Asia, approaches climate change as a financial risk issue. I'm then going to talk to you about the way that the Australian fiduciary law approaches directors' duties. And then the third thing I'm going to do is put the two together and talk to you about how our law has dealt with directors' duties with regard to climate change. So to start with a bit of context, I'm from Pollination Law. I'm the managing director of Pollination Law. Pollination Law is part of the Pollination Group, which is a professional services group that deals with all aspects of professional services across natural capital, from law to strategic advisory to projects to investments. We have a billion fund, asset management fund with HSBC. Our two largest shareholders are two of the largest Asian banks, ANZ and Mizuho. I'm a corporate lawyer. I've been a corporate lawyer for 30 years. I'm a shareholder primacyst. Until recently, I've been on the board of one of Australia's largest pension funds. As a corporate lawyer and a shareholder primacyst, I do not care about the environment or the community. I care about money and I care about risk. And that is why I care about climate change. So Australia, our economy, very resources heavy. Two largest sectors in our economy, we dig stuff up and we have financial services. We have not, much like the US, have not had a regulatory-led response to climate change. It has been led by a pension sector, which is the fourth largest in the world. We've had compulsory superannuation for the last 35 years, so we've got the fourth largest pension pot anywhere on the planet, disproportionately large compared to our economy. And our superannuation funds are also disproportionately heavily invested in domestic equities. As a consequence, the approach to climate change has very much been driven by that investor cohort in recognition of the financial risks and opportunities associated with climate change. I can't help it if the mic's on. Move it a bit closer. Is that better? So pension funds understand no one's going to make money if we tip over 2 degrees. We get that. And so as a consequence, the focus from the outset has very much been on the financial risks and opportunities associated with climate change. That's consistent across Australia and consistent across Asia. So when you look at things like the World Economic Forum saying 5 out of the top 10 risks to the global economy by likelihood and impact are directly associated with climate change. Funnily enough, the other one that sneaks in there is misinformation and disinformation. So I wonder why that's going. When you look at the NGFS that represents the world's central banks and prudential regulators, talking about the fact that GDP is going to be impacted by up to 40% over the next couple of decades because of climate change, updating their damage functions from the physical risks associated with climate change between 200 and 400% in the last couple of months. You start to understand why, from a financial risk perspective, the rest of the world is looking at what's going on over here at the moment and going, great, you guys are all crazy. We're going to be the ones who actually make money out of this stuff. And you're just building in a whole stack of stranded assets into your portfolios. So that's the context from which I'm coming in Australia. How about our fiduciary laws? Well, we follow the classic corporate governance structures in relation to fiduciary duty. Duties are under our Corporations Act, and they're threefold: trust and loyalty duty, duty to act in good faith in the best interest of the corporation, not shareholders, of the corporation, under Section 181 of our Corporations Act. It's subjective with a gloss being if you're acting in a way that no reasonable director could have acted, then you can still be liable for a breach of your duty to act in good faith in the best interest of the corporation. Due care and diligence, duty of competence under Section 180 of the Act, holds directors to a standard that a reasonable director would act in the circumstances. That is objective and subjective. Objective insofar as you look at what a reasonable director would do. Subjective insofar as it is in the circumstances. So a very different standard of care if you're a director of a large listed corporation versus if you're a voluntary director of a small charity. The standard to which you're held is going to differ. The standard to which our directors are held, though, is bare negligence. It's not gross negligence. There's no scienter. The business judgment rule does not apply as a presumption. It applies as a defence. And it is a very, very limited defence. It's been successful in our jurisprudence once. And the reason for that is that usually the way that you breach your duty of due care and diligence, because you're not making a judgment, you're just not considering an issue, or you're not acting in a way that is adequately informed, that's when the business judgment rule applies. And usually that's the reason you breach the duty of due care and diligence in the first place. And the third duty is in relation to disclosure, assurance, misleading disclosure, for which directors can be primarily and accessorially liable. The test is what is the overall impression that a reasonable person in the audience would take from the relevant disclosure. Again, no need for scienter. No need to show loss or damage. You can get declaratory relief by reference to, well, what would the hypothetical reasonable person take from this message? And we've recently had a greenwashing claim against Mercer, one of the world's largest professional services firm, where there was no loss or damage shown. There were 4 words on the website, and they were fined 11 million Australian dollars for greenwashing. No scienter, no loss or damage. So it's a very, very plaintiff-friendly regime. Enforcement not only by way of shareholder derivative action, but also by our regulator, ASIC, the Australian Securities and Investments Commission. Our regulator can bring an action for a director breaching their duty of due care and diligence. And in fact, most of our jurisprudence on point has been in cases brought by the regulator. They bring cases where they see the potential for damage by retail shareholders in particular, and so bring the action on them. So we've got a context where climate change is absolutely recognised as a financial risk and opportunity. We've got a context where our corporate governance laws, the bar is very low, the standard is very high. We've got a very plaintiff-friendly standing regime. So what's happened in terms of cases? Well, 10 years ago, there were a few of us who had started talking about the fact that all the literature focused on fiduciary duty and climate change had been focusing on duties of trust and loyalty. Is it in the best interest of a corporation or a pension fund to think about climate change? And that discourse occurred in the context where there was a presumption that environmental issues and financial wealth were mutually exclusive. And those of us, and Mike Gerard included, I remember having a conversation in his office about this more than a decade ago, like, well, hang on, it's a financial risk issue. It's the wrong question. It's clearly in the best interest of the corporation to be thinking about these issues. It's a due care and diligence question. What do you have to do when you think about it? What is enough? So with the Commonwealth Climate and Law Initiative, and I acknowledge that Cindy and Tom are both directors of the Commonwealth Climate and Law Initiative along with me, we had a strategy whereby we commissioned legal opinions all around the world. The first was in Australia. Now, Australia has a bifurcated profession. We have solicitors, we have barristers. Barristers are the ones who stand up in court and revered as senior counsel. We found the technical legal term crustiest, oldest, most conservative corporate barrister we could find and presented him with a dossier of evidence about how climate change had evolved from being a lefty, greeny, hippie socialist thing to being a financial risk and opportunity, and asked him to opine on whether or not that meant that directors were duty-bound to consider climate change when they were exercising their fiduciary duties. His name was Noel Hutley. He opined, hell yeah, technical legal term. Directors are required to take these issues into account in order to discharge their duties to the corporation. That opinion was then cited by all our regulators, our securities regulator, a prudential regulator, a Reserve Bank, and all of them were grateful that it had given them a little bit of political cover to be able to come out and say, yeah, we understand this is a financial risk and we're going to apply our laws consistently. So the regulators are of one mind on this. So how about the jurisprudence? We actually haven't had any cases litigated to finality on due care and diligence in relation to climate change. And given the context I've laid out, why is that? A couple of reasons. There have been a few cases where it's been raised as a cause of action and they've settled because, of course, insurers don't want law on this. No. So there have been a number of cases, one against the trustees of a pension fund, rest case, and another, and I wish Brad was still here, against our equivalent of the comptroller federally, alleging that he had breached his duty of due care and diligence by failing to ensure that the disclosure documents in the issue of Commonwealth sovereign bonds contained discussion of climate change as a financial risk. Why haven't there been more cases? Well, I can tell you they are absolutely being leveraged behind the scenes as a lever to change corporate action by banks, by pension funds, by companies in general. And really, from an activist point of view and from a regulatory point of view, misleading disclosure is far lower hanging fruit. And that's where the focus is. Because, as I say, where you've got a regime where there's no scienter, is this likely to mislead or deceive? Greenwashing is so easy to establish. And so that's where the focus has been. So I'm getting the 1 minute sign from Martin. So I'll close my comments there, but I'm really looking forward to this discussion, and I'm certainly more than happy to respond to any questions about how the rest of the world is looking at and responding to the political events in the US at the moment.
Okay, what in the world ever convinced me to follow Sarah? But at least Sarah has pointed out the financial risk that is the core of all that we're doing at the Commonwealth Climate and Law Initiative in commissioning opinions on the fiduciary obligations of officers and directors in operating companies and banks and pension funds. To date, we've had opinions commissioned in Australia, the UK, Canada, South Africa, Hong Kong, Singapore, India, Japan, Malaysia, the Philippines, and Indonesia. Well, we're working on Indonesia. Sarah and I wrote an analysis of in the US, and we are in the process of commissioning an opinion in the US. But I'm here to talk about Canada. I had the opportunity to teach and live in Canada for about 10 years. I still have a house there if anyone needs a refuge. And I thought it's probably useful to think about the relationship between Canada and the United States at this point. Canada is the largest trading partner of the United States other than Mexico. And Canada is the #1 jurisdiction for exports from the United States. So when you think of exports from Canada to the United States, you probably think of excellent maple syrup, and that's true. But the United States also imports a large percentage of its electricity in the Northeast from Quebec, a very substantial portion of its oil and gas in the Midwest from Alberta. It imports lumber from Canada, and the automotive sector in the United States is entirely integrated with Canada. Parts in a car that's ultimately sold from Detroit have gone back and forth across the border between 4 and 6 times. So I am here to say Canada is absolutely, technical term, pissed. Very, very substantially afraid that their economic sovereignty, at the very least, is being threatened by the tariffs that have been threatened. So anyone with relationships with Republicans, please tell them it's not going to help any of us. All right, context, finished. Political context of the moment. I don't think we can ignore what is happening in our country right now. And I think that, you know, talking about Canada, I find myself feeling very Canadian. Anyway, I am US and US citizen. So what does Canadian fiduciary law say about these systemic financial risks? And I'd like to talk about fiduciary duty in the corporate law context and some regulatory developments and some ways that those regulatory developments might affect developments in the United States. And then compare, again, the plaintiff-friendly versus non-plaintiff-friendly aspects of Canadian causes of action. Like fiduciary duties across the Commonwealth and common law, Canada recognizes a duty of care and a duty of what we would call loyalty. They call it simply the fiduciary duty, and then disclosure. The director's duty of care in Canada is to exercise, you know, the skill and diligence that a reasonable person would exercise in comparable circumstances. It is not considered a fiduciary duty per se, and it is not given the same, and I don't think it really matters that it's not considered a fiduciary duty, but there is no exculpation in Canada. It's not permissible to exculpate your officers and directors as it is permissible in the United States. The business judgment rule is not nearly as strong as it is in the United States. The Canadian courts will look at the context in which a decision was made. They will look at what information was available to the directors when a decision was made and evaluate whether the directors met their duty of care, diligence, and skill. So that gives rise to the possibility that there could be litigation in different industries. And in particular, as Sarah points out, if the directors have utterly failed to consider climate change in a relevant context, there could be litigation there. Now, the fiduciary duty, what we would call the duty of loyalty, is to act honestly and in good faith for the best interest of the corporation. It is explicitly a stakeholder-oriented duty. There are two cases in the Supreme Court of Canada where the Supreme Court of Canada explicitly made that clear and said no one stakeholder interests prevail. And in order to make the decisions of the Supreme Court of Canada explicit, the Canada Canada Business Corporations Act was amended and now states that in advancing the best interest of the corporation, the directors should have consideration of, among others, shareholders, employees, pensioners and retirees, the community, and the environment. So it's quite clear that Canadian directors could be liable for failing to consider relevant climate change financial risk, either under their duty of care or under their duty of loyalty. Now, in its own sort of slow, methodical, thoughtful way, Canada is also moving in the direction of requiring more climate disclosure from large financial institutions and large publicly traded companies. The Bank of Canada and OSFI, the Office of Supervision of Financial Institutions, is the first really to act. They've been doing pilot programs with their largest banks, and Canada, like Australia, has a highly concentrated financial context, right? We have 5 major banks. And in those banks, they're now requiring disclosure of governance and strategy, and also an annual report on how climate change and their scenarios are potentially affecting operational resilience. The structure in Canada of securities regulation is provincial. So we are flipped vis-a-vis the United States, right? The corporate law is federal, securities law is provincial, although the provinces work together they have a passporting system, and they also work together to establish standards. They have a consultation that's been underway for quite a little while, I must admit, on disclosure. But again, it's based on the TCFD context of disclosing how is a company evaluating risk, how are they managing it at the board and governance level, and if they have metrics and targets for reductions in greenhouse gas emissions, what are they, and how are they doing? And the Competition Bureau has acted also in order, and it has actually acted faster than the securities regulators in addressing deceptive marketing practices. RBC is under evaluation from the Competition Bureau for having overstated its net zero commitments. Now, something that I didn't know until I was teaching in Canada is that the United States and Canada have something called the multi-jurisdictional disclosure standards, MJDS. And what that means is that Canadian companies can list in the United States and using their Canadian disclosure, and vice versa. So American companies, if they wanted to list in 13 provinces, could go forward with their US disclosure. As you might imagine, most of the listing is southbound. But we are going to start to see, as of next year, some of the climate disclosure from Canada in their US disclosure. And so perhaps investors might see that disclosure as worthwhile and start to continue to put pressure on US companies to include such. So let me wrap up to just say quickly, like Australia, we don't have these cases yet outside of, as I say, the Competition Bureau looking at RBC. However, I know that cases are being developed. And there are some ways in which Canada is more plaintiff-friendly than the US. As I've said before, the business judgment rule is less protective. There is no exculpation, and standing for derivative litigation is much broader than in the US. It includes shareholders, but it also includes directors, officers, former directors, former officers, creditors, and, quote, any other proper person. And the first step in derivative litigation is to go to a judge and advance the argument that this derivative litigation should go forward. It has a good faith basis for the claim, and there is some possibility of success. So the Canada regulation and regulators look to the United States constantly to see what we are doing. And the Canadian securities administrators and the provincial securities administrations have been holding off until after the SEC issued its climate disclosure rule. But I am happy to say that they do seem now to have decided to continue with their consultation and to go forward. And the one thing that I can say with confidence that Donald Trump has done is unify Canadians in a way I have not seen before. The West and the East are on the same page, and that's unusual. Thank you.
I go next? Okay, so after hearing about how things work in the courts of our common law brethren in Canada and Australia, how do all of the US lawyers in the room feel at this point? When I started investigating what they were up to in connection with writing my paper, Caremark's Climate Failure, I definitely felt like doing a facepalm, right? Because we're not there. The UN commissioned an opinion from the Devon Boys law firm about climate, well, ESG risks in general, but climate risks and the obligation to directors to consider them, and concluded, unsurprisingly, given where our jurisprudence is, that there is an obligation of directors to consider climate risks when they are material, reasonably available material information in connection with making a decision under the duty of care. However, there is no generalized obligation of directors to think about climate risks, to gather information about climate risks, or to be prepared to address climate risks, because the Caremark jurisprudence applies effectively only to legal compliance risks. And generally speaking, climate is not covered by legal obligations that directors need to consider. So that's where we are in the US. The question is, how did we get here? And what do we do about it? So in terms of the how did we get here, I think that there are sort of three frames: moral, policy, and utilitarian, that undergird the sort of US jurisprudential approach to what you might call enterprise risks, of which climate risk is one. And I'm not going to spend a lot of time on the policy. It's obviously very well tread of, well, if we have too much liability for directors, then expert people will choose not to be directors, and those people who actually do choose to be directors will behave in ways that are overly risk averse, and we won't have the dynamic economy that we have. Moral. So interestingly, you may not be aware, but in the Caremark case itself, Chancellor Allen said, one wonders on what moral basis might shareholders attack a good faith business decision of a director as unreasonable or irrational. And that statement by Chancellor Allen in Caremark and his ultimate conclusion about how risks should be handled and the process he describes for handling risk in the Caremark case reflect, and I think echo, interestingly, an article that was written by Bayless Manning, the dean of the Stanford Law School, former dean of the Stanford Law School. And when he wrote the article in The Business Lawyer in 1984, it was during the pendency of the Smith versus Van Workum case. And he was talking about what are the circumstances in which directors should be liable for inattentiveness. And he basically said, they should not be liable for a single instance of inattentiveness. When we look at the director's job, we need to assess it on a flow basis. Sorry, my opera singing parents' DNA is not coming through, I guess. That we need to look at what they're doing over time and consider what they are, their approach to their job, and are they acting in good faith? And are they doing the procedures that are necessary to be done, which is, of course, effectively where Allen came out in the Caremark case, where he said that there is an obligation to establish systems to gather information and to monitor those systems and that they need to do that in good faith, and if they fail to do that, then they should be liable. So there is a moral underpinning to this perspective of the US courts. I guess I would argue that felicitously, when it comes to enterprise risk in general and climate risk in particular, that handling risk is effectively, naturally, a flow state process for the directors. We're not assessing their assessment of climate risk at any particular moment. We're assessing, have they made a good faith effort to review what potential risks to the corporation are, to establish information systems with respect to them. And so I think there's a strong moral case around oversight responsiveness. What about utilitarian? So Holger Spaulding has written an article about the duty of care and the business judgment rule and when it should apply, in which he basically has a utilitarian perspective. And he says that judicial decisions are neither going to be effective or legitimate unless they are reliable and consistent. And he actually says then that the Caremark framework actually is a high level of reliability and consistency because it's relatively binary. Either you have established a system to gather information about something or you haven't. And either you have monitored it or you have not. And so that is capable of reasonably reliable and consistent decisions by the judiciary. The challenge then becomes, well, as to which risks do you have to establish an information system? And isn't that a question of business judgment? And of course, Chancellor Chandler in the Citigroup decision and Steve Bainbridge and Robert Miller have written very persuasively about the notion that which risks you manage and how you manage those risks are fundamentally business judgment rule points or questions, and that they are decisions that should not be reviewed by the courts. Holger, in his article about the duty of care, talks about the challenge of reviewing business decisions because they are idiosyncratic and they are not subject to expert review or expert information, because each business decision about how to expend resources of a business are highly fact dependent and idiosyncratic, and so they don't lend themselves well to expert application of expert information. I guess I would say yes, as to use of corporate resources, that often is going to be the case. But I think that in the question of is it possible to apply expertise to the question of what issues or what risks should we be investigating, which risks should we be gathering information about in order to ensure that they don't end up destroying the corporation, as the directors of PG&E found out to their chagrin when PG&E's power lines blew up the town of Paradise in California and led to the bankruptcy of the firm, that we actually can apply some expertise to this question of. And I would argue that we ought to be making efforts to apply. So instead of thinking about these issues as a question of judicial competence, whether judges are competent to review or not, we should think about, are there systems of expertise that can be applied by judges in a way that is reliable and consistent? And as to that, I think the answer is yes. And there are three possibilities of sort of expert bodies that you can apply. One is just the consensus of the community. So the community consensus as a source of expertise, which seems to be the place where the opinions of the lawyers in Canada and Australia have ended up. That, you know, the community knows that climate is a huge risk, and therefore it would be unreasonable not to respond to that, is a form of community expertise. I suspect that Delaware judges would be highly reluctant to apply community expertise as a source of expertise in their decision making. But there are two other sources of expertise that they can apply. One is expert networks or expert systems, which are available here. Enterprise risk is reviewed by COSO. There's a clear system of expertise about what is at risk that an enterprise should be reviewing, gathering information about, etc. How about COSO? Or alternatively, how about SASB? SASB has established a system of expertise about what are material risks to corporations that should be reviewed, particularly in the climate context. So you've got that. Madison Condon has written about the availability of climate stress models, which are another source of expertise about what risks particular enterprises face, particularly in the climate context. So we have sources of expertise to apply in this context. Finally, and what I suspect would probably be the Delaware judiciary's favorite source of expertise would be the directors themselves of the corporation. So how do we know what the directors consider to be the material risks to the corporation? Well, if it's a public corporation, they have presumably elucidated those risks in their public filings with the Securities and Exchange Commission. They have an obligation to do so on an annual basis in their Form 10-K. So I would suggest to you that if the directors of a U.S. corporation have suggested that climate is a risk to their corporation in their SEC filings, and they do not have a system for gathering information about those climate risks and monitoring them on a regular basis, they probably have a care mark problem, or at least they should, even though it's not a legal compliance issue. But there is the corporation itself has said, this is an issue for us. One would certainly hope that then they would be establishing a system to monitor it and actually monitor that system. So that's Caremark's climate good.
So I'm actually going to stand because it brings some energy, at least to me, maybe not to the room. And I have some slides as well. So I've been asked to speak to two things. The first is to characterize briefly the state of corporate law and its interaction with climate change in the UK and in the EU. And second, to also reflect briefly on what the paths forward might be to increase the salience of climate change in corporate governance. So I'll start with characterizing the systems of corporate law in the UK and in the EU, starting with the UK. So UK corporate governance, as you may see on the slide, once we get to the next slide, can I control it? Or great. Okay, so UK corporate law is very, very strongly premised on the primacy of shareholder interests, probably stronger than UK corporate law, in any other jurisdiction. So what the duties of board members entail is to act in the interests of the company for the benefit of the shareholders as a whole. And they have to do that in good faith. Now, that's the position of statute, section 172 of the Companies Act, but also very clearly the position in case law, most recently, I'd say, clearly articulated in a case called Sequana. There are duties that directors should consider. In other words, they have to consider the interest of other stakeholders, of the environment, of long-term value creation. But those are primarily hortative, I would say, because all these other stakeholders cannot enforce directors' duties. And so, plus, all the interests of other stakeholders have to be considered expressly in an instrumental way to further the interest of the company, again, for the benefit of the shareholders as a whole. What is interesting about UK company law is that directors' duties are owed to the company. And so the only party that can enforce them is the company, or exceptionally, the shareholders on behalf of the company through a derivative action. So private enforcement is the name of the game in the UK. There is no such thing as there is in Australia, where, say, a regulator can bring these kinds of claims. And I say exceptionally in the case of derivative actions, because the standards to bring such an action are very, very high in the United Kingdom. One case that illustrates this well in the climate context is a derivative action brought by the NGO Client Earth against the oil company Shell, where they alleged that Shell, despite having pledged to go to net zero, didn't implement proper measures and policies to operationalize that pledge. That was a duty of, there was a derivative action that was effectively thrown out by Justice Trower without even considering seriously the claim in front of him. Basically, he threw out the case because Client Earth was thought to have improper purposes in bringing the claim. They're not really interested in the interest of the shareholders, Justice Trower said, but they're mainly interested in their own sort of policy proposals as an environmental NGO. So he threw out the case. Now, that's not a result that was particularly unexpected. The reasoning was unexpected, but the result wasn't unexpected given the very high procedural bars to bring derivative actions in the UK. These cases almost never succeed. However, I wouldn't say the door is entirely closed because one former Supreme Court Justice, Lord Carnwath, then responded to Justice Trower's opinion saying that he felt another interpretation was possible. And on that interpretation, the court should have engaged with the substantive argument. And according to Lord Carnwath, that would potentially open a door. It wouldn't be inconceivable to have derivative actions in the UK against directors, also in the climate context. But I would say it's very, very unlikely because in the UK, accountability of management is organized primarily through other means, very notably through removal rights. So shareholders can remove directors with a simple majority in the UK. And so accountability just takes a different method there. What about then the EU? Well, first of all, I should say you can't really speak about EU corporate law because there are many, many jurisdictions, there are different legal traditions, and so company laws across EU member states don't actually look the same. But there are a few things that we can say, and I'll reason from a jurisdiction that I know best, which is the Netherlands. And of course, there will be exceptions to this, which I'm happy to talk about with respect to other jurisdictions in the Q&A. So, in contrast to the UK, the EU adopts much more of a stakeholder model. At least that's how it's being branded. So what I would say is the functionally accurate description of EU company law is that it puts the strategic decision-making within the realm of the board. So the board has a much stronger position in articulating the strategy of the company than, say, shareholders, and the role of stakeholders in the considerations of the board are much, much stronger as well. Now, that's the theory. What is true also is that the board, in carrying out this role, has much more leeway than the board in the UK has because it's less strictly accountable to shareholders. It's much harder, for example, to remove directors, and it's much harder also to table motions at an AGM. So that's the theory. I would say in practice, though, most jurisdictions in the EU still give primacy quite strongly to shareholder interests because they have the most enforcement mechanisms available to them vis-a-vis the board. So that doesn't mean that shareholder actions are impossible in the climate context. In fact, there have been some very successful ones. An interesting one in Poland is again brought by the environmental NGO Client Earth versus the energy company Enea. And this was a case where Client Earth bought a share in Enea and then said the building of a new coal-fired power plant would run counter to fiduciary duties of Enea's board because it would lead to asset stranding pretty quickly. And so they asked the board to reverse that decision, and the court sided with them. And this is a major case, and probably the main case, I'd say, in the European context of such an action succeeding. What is interesting now is that there is a follow-up case where the new directors of Enea are suing the former directors of Enea for not having recognized this stranded asset risk to begin with, because they were given the legal advice that if they wouldn't sue the former directors, the subsequent board might sue them. And so you can see that under EU law, there's some possibility for claims of this nature. However, as I said, there are some challenges here as well. when shareholders try to table motions related to climate change, very frequently they're not able to do that. So for example, shareholders try to bring an action against Volkswagen, an automotive company in Germany, and they were not allowed to table the motion at the AGM. And so these kinds of obstacles still persist. But I would say by and large, both systems are actually much more similar than most commentary would make it out to be. It's really a matter of degree to which shareholders are in charge, but not so much a different orientation. And that also means that fiduciary duties remain focused on the interest of the shareholders. And actually across these systems, they do so through a financial lens, through the concept of financial materiality, which is sort of the bridge concept between climate change and corporate governance in these jurisdictions. And quite in line with Sarah's comments, that means that corporate law systems in the EU are largely agnostic to climate change. They're not active impediments to climate action, but they're also not clear catalysts. So what does this mean? Well, going forward. So I would say, first, we should not pretend, also not in the European or UK context, that corporate law per se is a catalyst for climate action. Shareholders can commit the company to act, as John Armour, Luca Enriquez, and I have written for the US context. This applies much the same in the EU context. However, there's very little evidence of shareholders willing to really commit the company to climate action. This is perhaps unsurprising because, as we all know from other areas of law as well, there are negative synergies between many corporate accountability mechanisms and externalities, because many corporate accountability mechanisms that prioritize shareholder interests are tied to the stock price. And if the stock price doesn't reflect climate change, then of course, these accountability mechanisms don't work particularly well. Reform of the core tenets of corporate law in the EU, UK is quite unlikely. So that means that any change to company law and to make climate change more salient shouldn't come from a change in the logic of the corporate law structure, but rather perhaps from a different operationalization of the existing concepts within corporate law. And to that effect, I want to offer two suggestions for change. One of them, I would say, is distinctly European. So let me talk about two things in turn. First, how we might reinterpret existing open textured concepts within company law to make company law more sensitive to climate change issues. And second, to think about some institutional complements to company law in bringing climate issues to the fore in corporate decision-making. So first, open textured concept. So I'll focus on the concept of financial materiality because I think that's the most salient concept. Again, bridging climate change issues and corporate decision-making in corporate law systems, at least in the UK and in the EU. And what is financially material is often presented as some sort of technical exercise to figure out how big a risk is, and then suddenly it should become financially material. That's perhaps the ideal situation, but in practice, financial materiality in most jurisdictions is very much a concept that is a social construct. So how do we reinterpret such a social construct? The first thing we can do is focus more on evidence of climate risk and how that relates to corporate decision-making. We know increasingly, as we've heard many times this morning, that this kind of evidence is quite strong. We also know, however, that somehow it doesn't make its way into the boardroom very frequently. Medicine has written about this as well. We don't know why. So we don't know if that means that the risks are just not material, whether the presentation of this evidence isn't consistent with how people think about risk in corporations, or whether they are potentially financially insulated from many of the risks or legally insulated from many of the risks of climate change. For example, in the energy sector, we have many long-term power contracts. That means that asset stranding is very unlikely in these contexts. So evidence and how it's interpreted, that's channel one. Changing industry standards is also important because of the reasonable director and the reasonable investor standards that underpin financial materiality being interpreted with reference to what the reasonable director and reasonable investor actually do. So as these practices change, the interpretation of those standards might change as well. Third, bringing these cases based on a project level is in the European context the way to go. at least, because it's very difficult for courts to find that corporate practices in general contravene financial, fiduciary duties in a climate context. But it's much easier to find, as was the case in the Polish context that I mentioned, to find that a particular investment runs contrary to fiduciary duties, for example, because of asset stranding. And finally, there are various regulatory innovations that change the interpretation of what is material. Roy Shapira and Matteo Gatti and Luca Enriquez have written about how the Corporate Sustainability Due Diligence Directive, for example, might change the interpretation of materiality for European context, but critically also for US companies because of the extraterritorial effect. So I will wrap up with my final comment about a distinctly European tradition, about the institutional complements to shareholder rights and how they might bring climate change to a more salient place in the boardroom. So EU policymakers have actually been very, very active in facilitating, stimulating this kind of detailed prescriptive guidance for companies in terms of how they should act on the climate front. Two things stand out in this respect. First, they want to facilitate more information, a better information environment because of a perceived agency problem between those running companies who want to appeal to green investors and green investors not knowing whether what the company is doing is actually green. So a lot of disclosure obligations, detailed disclosure obligations have been imposed. And I think that theory of change, though interesting, is quite flawed because it suggests that shareholders actually act on the basis of these kinds of labels, and that if only there are more green labels, then shareholder interest will follow. And we've now seen that, at least in the European context, that's not the case. And then second, and finally, in the EU, there has been very detailed, there have been attempts to impose very detailed decarbonization requirements on companies. And this happened through two channels. One is litigation. So there's been a tort-based claim against energy company Shell in the Netherlands to force it to accelerate its decarbonization strategy. That was successful in the court of first instance, then unsuccessful later on. However, the court did embrace the idea, the legal notion, that such duties exist. The court just felt it couldn't operationalize effectively any injunction. And that's the court. On the policy front, there is now an actual piece of legislation on the books under the, again, Corporate Sustainability Due Diligence Directive, Article 22, that mandates that companies reduce emissions. That is now an obligation that is unclear how it's going to be operationalized. It's also unclear whether it's going to exist for very long because of a reform effort to make EU company law more competitive. But let's assume that it exists. If it does, it will mean a major change for all companies that are within the scope of this obligation, which is extraterritoriality, which is applied to all companies, major companies doing business in the EU, because it will mandate a best efforts obligation for all boards to reduce their emissions. And that would, of course, bring to the fore, through a method other than company law, the role of climate change in the boardroom. Thank you.
Thank you so much to all of our speakers also for staying within our time frame. I've been told that we can go until 11 o'clock because of the earlier disruptions. So let me just pose a question first to the panel, and then I will open it to you all in the audience. I don't want to go back to ask an important question, I think, which Andrew has asked, is how did we get here? Which, of course, is an interesting question. If we all come from the common law, we all have fiduciary duties, how is it that the different common law jurisdictions diverge so much? But in some sense, this question already points to the real question I want to ask, and that's, I think, Tom has alluded to this explicitly, but all the speakers have spoken to this, which is the complementarity of institutions. So under what conditions does fiduciary or do fiduciary duties do what kind of work in different jurisdictions? What is the role of standing rules? What is the role of the interpretation then also of certain duties, like the duty of care in particular, or the defense of the business judgment rule, or the presumption of the business judgment rule? What is the interaction of the private sector and the private litigation strategies and the regulators? And there seem to be different models. So I just want to ask each of the speaker to think for a moment and maybe tell us if there's a package deal that you have in your jurisdiction from which we could also learn. I think I'm always very skeptical when people want to do like legal transplants. Let's just take this little thing from this jurisdiction, put it there. That rarely, if ever, works. But if we understand the logic of a system, how a complementary set of institutions works together, we might learn something how we could reimagine reforms in different jurisdictions, which would be necessarily context-specific and incremental, because that's how these reforms typically work. So could I just ask, maybe we just go from right to left, Cynthia, if you want to give start and say, what's the package deal for Canada that makes it either tractable, does effective in any ways, and maybe speak to this. Thank you.
Okay, thank you. Well, as I said, Canada is moving forward on various disclosure initiatives on climate change, and in particular, the large financial institutions and the public companies disclosing their governance, their strategy with respect to identifying climate risk and governing it, and then also how it might affect resilience and operational implications. It is, of course, the theory of disclosure that what gets measured gets managed. And there is some empirical evidence that disclosing quantitative information like greenhouse gas emissions has led to companies reducing those emissions. And the effect is stronger in public companies, and the effect in the United States is particularly strong with the largest public companies. So in Canada, there isn't as much litigation. Certainly there isn't as much securities litigation, but there are strong norms. And I do think that asking companies to disclose how they are governing, how they are evaluating these risks, they're going to have something to say. So I think that does push in the direction of the companies doing a better job, perhaps, at meeting their duties of care and loyalty.
So it's basically shaming in a relatively small jurisdiction.
Right, and I don't think that it's necessarily through investor pressure, although I wish there was more investor pressure, but I think it is through managers and board members taking on these responsibilities so that they have something intelligent to say about it.
Thank you. Sorry.
Yeah, similar to Canada, I think the mandatory climate-related financial disclosure regime that we are currently subject to in Australia, it came into effect on 1 January, is really the locus by which we're going to see a lot of cases. We have stepping stones liability, whereby if directors fail to oversee sufficiently robust systems of financial reporting, they can be found guilty of a breach of their duty of due care and diligence. So there's a bit of a distinction to the US, where failure of oversight is not a trust and loyalty issue. It's a due care and diligence issue. So just again, subject to that bare negligence rather than any kind of intention. I should say, actually, Canada and Australia are islands, even Australia's an island. In that regard, 57% of the world's GDP is going to be subject to mandatory climate-related disclosure regimes consistent with the International Sustainability Standards Board standards. Plus, you've got the Europeans with their CSRD. So I definitely think a failure by boards to ensure that the systems by which the company assesses and verifies and translates into the financial statements climate-related risks and opportunities is really going to be the area in which the jurisprudence in the directors' duties landscape in Australia will go forward.
So if I can say, the package is then a robust disclosure regime with a very robust litigation regime based on fiduciary duties. Is that fair? Thank you. Tom?
I think for the So I think for the UK, as I said, the change doesn't really come from within company law. What UK company law does is just empower the shareholders strongly. And if shareholders feel that companies should green themselves, then they have a lot of power to force that through. If shareholders think that companies shouldn't do that, then that's very, very difficult. It's very difficult under the UK company law setup to change that. There are, of course, very strong disclosure obligations in the UK. The UK government was one of the first to make mandatory climate risk disclosures for major companies. However, it did so with a materiality filter attached to it. So as a matter of fact, not that much changed, I would say, through the adoption of these specific policies. In the EU, the theory of change, as I said, is quite different. And the way that institutions complement each other is different. So EU company law isn't necessarily much more supportive than UK company law, where, for example, in Germany, stakeholders get more of a say because of employee representation on boards. It turns out that these stakeholders tend not to be much more pro-climate than shareholders because they're worried that a transition to, say, electric vehicles would put their jobs on the line. So that's not really where the change comes from. Under the EU regime, the change comes from mandatory policies imposed on the company. So I mentioned disclosure obligations, but I think it's really the detail of those obligations. So if you look at the EU disclosure mandate, the Corporate Sustainability Reporting Directive, the CSRD, combined with the technical implementation standards, you'll find that companies have to report hundreds of data points. And that means that they have to revamp the way they function internally. And that has major governance implications. And then this duty to decarbonize, that's really the talk of town in the EU, because if that's imposed with a best efforts obligation attached, then every company will have to think about what it means in their context to exercise best efforts. So these are the channels of change in the EU that are emphasized much more than company law, but have a clear bearing on how corporate governance is organized in the climate context.
So if I hear you correctly, then basically a regulatory regime is more likely to impose real change than relying on shareholder value driven investors in the UK.
I'd say so. And I should add perhaps the courts.
In the courts. Okay, yeah. Thank you. Andrew. What is missing?
Wish list for America. So I think, first of all, I would just point out that as Roy and his co-authors have written, as Tom mentioned, it's highly likely that the European Sustainability Due Diligence Directive will be the Mack truck that basically brings US companies to the climate table, or to more broadly to the sustainability table, precisely because it sort of is the magic bullet which creates a legal obligation to consider all of these sustainability issues, which then makes it justiciable under the current Caremark jurisprudence. And so maybe that's it. Maybe it's done. Wish list for America is done because the Europeans have applied their law extraterritorially to us in the way that we have to them in so many regimes in the past. And that may be the issue. I guess I would just say one other thing, which is, well, two other things. One, so one of the gobsmacking differences between the US and its common law brethren, as discussed earlier by Cindy and Sarah, is no exculpation. In our common law brethren countries, we have exculpation in the United States. Personally, I would love to see a revival of the American Law Institute idea that came up when 102b7 was being considered, which is that we should have liability for directors, but it should be very, very limited. It should be limited to their compensation, not to the entire size of the corporate liability. That would create incentives for directors to do their jobs more effectively without the fear of blowing up, and also would have an ameliorating effect on the challenges of insurance.
Yeah.
So.
Okay. So I want to open it now to the floor. So you heard the different perspectives. I was trying sort of to consolidate some of these issues here. If you have questions, please raise your hands. Eric, I see your hand up already. Eric Orts. From maybe just introduce yourself so others know that who you are. Thank you. There's a button maybe.
Oh,
Yeah,
there
here we go.
we go.
With red, it works.
Okay, sorry. My name's Eric Orts. I'm from the Wharton School at Penn. I guess one comment and then a question. The comment is that I think there's a tension in the conceptions of fiduciary duty that have been indicated with respect to the idea that you have fiduciary duty to shareholders, and then there's a competing idea that there's a fiduciary duty to maximize financial value for shareholders. And I think that's important. So to Tom, well, thanks very much for the description of the UK, but I think in a way there's a difference there where, as you just said, empowering shareholders means that shareholders could, and some of them really do, care a lot about the climate. But on the other hand, we have new restatements of the American Law Institute, et cetera, in the US, where there's essentially an equivalence of shareholder interest being financial profit maximization, which I think is really quite different. The other question for the panel has to do with disclosure, and the comment about European, where Europe is going on this is important. One way of thinking about disclosure, and I've written a lot about disclosure positively, but a lot of critics of disclosure say that's what's easy for corporations to do. So the easiest thing to do with respect to climate performance is to disclose what you're doing. And then if it's not that much, who cares? But it seems to me what the European Union is now doing is saying that's not enough. You have to disclose, but then you actually have to meet targets of decarbonization, which I think is where we are, where we need to be now. So there's a general theme here of even if we had good disclosure, is that really moving the needle at all with respect to actually getting to the decarbonization, which maybe we need mandatory regulation to achieve?
Okay, so who wants to go first in responding to this? Yeah, sorry.
I'm happy to take it. First, thank you, Eric. I think the distinction between shareholders caring about climate and the wealth maximisation objective is a distinction without a difference when you look at climate change as a material risk. The magnitude of that risk is greater, particularly if you look at what's being walked back in the US at the moment. It significantly increases physical risk in the immediate term, significantly increases transition risk, even if regulation's being walked back, because it's blowing through the chances of there being an orderly transition. It means there's going to be a disorderly transition with a lot of disruption and a lot of acute shocks. So the magnitude of the risk is a lot higher. And so company directors who have to steward strategy and oversee risk need to take those issues into account. In relation to disclosure, again, if you're looking at disclosure as a mechanism to be talking to your investors about information that's decision useful, again, material financial risks and opportunities, they have to be connected to the financial statements. Everything that we've been disclosing qualitatively under TCFD about what is a financial risk to, what is a material risk to financial prospects, that impacts on your balance sheet. What's the discount rate you apply? What's your provision for bad and doubtful debts? How does it impact on your non-current asset valuations and impairments? And that is also where I think there's a big gap at the moment. It hasn't been done well. And where there are these mandatory disclosure laws that require you to be disclosing things that are financially material, ipso facto, oh my God, I used Latin in a legal context. You have to connect the dots to what it means for your balance sheet. That's beyond what we're doing, what we're not doing. It's the so what. So what does that mean? And that is where I think the big difference is in relation to the new disclosure financial reporting regime obligations.
Tom?
Yeah, just really good points, Eric. So quickly on the equation of fiduciary duties with shareholder wealth maximization. So you're right, under UK company law, managing in the interests of the shareholders as a whole can be interpreted, the interest can be interpreted by the members. It's just that when you start litigating this, for example, in a derivative action, it tends to be the case in the jurisprudence that any non-financial motivation is treated as suspect. So very frequently in practice, the two are aligned. On the disclosure point, I think what the disclosure requires companies to do is to set up de facto due diligence operations internally. And I think that's a significant governance change. A significant challenge in the disclosure frameworks is that you report your assessed risks to climate change against what you think the future will look like, against what you think physical risks and transition risks and legal risks will be in the future. And these are scenario contingent statements. And so one of the things that is under scrutinized in disclosure obligations is how do companies pick these scenarios? And might they, for example, pick scenarios that are inconsistent across companies or that are inconsistent with a reasonable assessment of where the world is going? And if you allow for that, then these disclosure obligations become pretty easy to game in practice, and then they lose a lot of their value. And so I'm writing about this with a few colleagues in Oxford, and it's actually shocking how much even minor changes in scenarios can dramatically shift assessed risk to climate change for, say, energy utility companies. It's orders of magnitudes with very minor looking changes. So that undermines potentially the efficacy of that strategy.
Do you also want to respond, or should I take some more questions?
Could I just say in relation to that, if a company is taking a business as usual set of assumptions to apply across their forecasts, fine. You got to run that across your balance sheet as well. So what does a 2.5 degree, 3 degree, 3.5 degree world mean for physical risk? How are you taking that into account in relation to your maintenance provisions, your plant and equipment valuations, your impairments, et cetera, which again isn't being done. And I think that's an area that there's is really ripe for us to be calling bullshit. Sorry, I'm Australian. We swear a lot.
Latin and
Australian Latin.
And just quickly, I just finished an article trying to look at the empirical data on disclosure, and I can't say that I pulled everything together, but the results that I did, use showed that quantitative disclosure could have an implication on greenhouse gas emissions reductions. Excuse me. Qualitative disclosure, it's not as clear.
Thank you. Any more questions? Yes, in the back.
Yeah.
You have press again. Doesn't work.
Okay.
Here we go.
Yeah. I'm an LLM student here. Yeah. Thanks for this so engaging discussion. So I do want to ask, regarding with respect to disclosures, that absolutely there needs to be a balance between something like we move on to over disclosures and disclosing. Like if we come on to the scope 3 disclosures, like disclosing along the whole supply chain. So what do you think about, because there are critics of scope 3 disclosures, how far do you think that scope 3 disclosures are really, realistic in a sense, and we are not going too far? So what needs to be an appropriate strategy? We are not even burdening the company so far to actually go more on disclosure. And how can we just approach it, and how do corporate entities can actually chart out this path so that they actually do not fall upon it? Thank you.
With your permission, I'll take a second question, and then we go one more round. Yes, go ahead.
Thanks. Ilmi Granoff, Columbia Law School. This is a U.S. question. I'm interested in whether some of the EU rules potentially create a sort of Pandora's box of care mark obligations. So the degree to which, obviously, obligations on legal compliance risk for U.S. companies that have European operations, but also whether once that gets triggered, it might further open the question, once they're seized of the issue of climate change, the boards are seized of the issue of climate change, further sort of U.S. obligations on how they dispose of that duty, how they treat the risk, whether they've followed through under Caremark. to seize of the risk more generally.
Thank you. So let's just go around. I'm just watching the clock, and since we're already a little behind the schedule, I want to close at 11. So we'll just go one more round. I think, Sarah, you want to respond to the first question?
Yeah, I'll respond to the first question. And again, coming back to financial materiality, how many companies have a material financial risk associated with scope 1 and 2 compared to how many companies have a material financial risk associated with scope 3? If you are a retailer, 95% of your footprint is upstream scope 3. If you are an oil and gas company, 95% of your footprint is downstream scope 3. If you're a pharmaceutical company, both. If you're a mining company, both. So to me, it comes back to what is financially material for you. If I am a retailer and I am not disclosing and not considering my scope 3 footprint, that is not the information that investors find decision useful. If I'm an oil and gas company and I'm talking about all this wonderful stuff where I'm going to do CCS for my scope 1 and 2 footprint, which is 4% of my value chain footprint, you're not seeing the forest for the trees. The risk is downstream pricing of carbon. So with all of this, again, to my mind, it doesn't matter if scope 3 is actually mandated under the disclosure regulations or not. If that is what's financially material, you need to be considering it and you need to be disclosing it just under the laws we have on the books already.
Thank you. Andrew, I think the camera question was maybe.
Yeah, the answer is yes, absolutely. It's going to create more pressure for directors to consider climate and more broadly sustainability, human rights, because ultimately it's focused on supply chain management. And so US companies that are covered by the EU directive will have to take their supply chain management obligations very, very seriously. Now, felicitously, the American Bar Association has issued a set of model contract clauses to assist companies in managing their supply chains. And so I would imagine that US corporate lawyers will now be in a position to advise their clients about how they can utilize contract clauses to effectively manage their new potential risks under the Sustainability Due Diligence Directive.
Tom?
Yeah, the only thing I can add is the two things I can add. One, read the paper that Enriquez Gatti and Shapira wrote, because it's exactly on this topic and it's phenomenal. The other thing I'd say is, what is interesting in this political climate is whether the kind of extraterritorial reach of EU regulation is going to be something that the new administration is going to accept. And of course, what I would put on the table is that, it's very predictable that US companies will lobby for it not to be applied to US companies and not to create that synergy with Caremark. And, it's kind of easy for us to ignore that this is the new reality, but I suppose, we can't really.
Yes, the Brussels effect against trade sanctions, exactly. I would say, is the future scenario. Cynthia?
Well, I, have to try to be an optimist and hope that in this political context, companies who have already invested in climate aware operations and management, I have to assume will want to keep their policies and their operations going forward. And I think it's really important for us that forward-thinking companies be encouraged and be supported to continue to do what they're doing, even if they're being somewhat quiet about it because of the anti-ESG and the anti-climate and the anti-science approach of the new administration.
Thank you. Thank you all. Thanks for the panel.